Neha, bonjour to the online world. So perhaps we are going to discuss about intellectual property rights. A little bit I'll be touch basing on particular section of the Indian Patent Act. Indian Patent Act was enacted in the year 1970, and a lot of changes have happened over the years. So I'll put myself on mute, wait for a couple of minutes before we restart. And particularly, we are going to talk about a section which is called as a hearing section. Um, in last 2 decades, a lot has happened, particularly from the standpoint view of understanding that technological technologically things are moving very fast, and it is so fast that the strategy behind the same needs to be understood in a manner whereby whatever you're developing, particularly from the standpoint view of a service industry where you're actually collaborating the software part with the hardware part, and the enactment and the deployment of the software onto the hardware is the question you need to answer when you are creating your own portfolio of applications. It is not very important to have a very granted application, but what is important is to have a trade secret. And when we talk about trade secret, even till now, the best of the companies which have worked last, I would say rather 100 years perhaps, are the countries and the companies which have kept their trade secret as trade secret. And given it's a big arsenal, every business of any level, whether you're trying to achieve whatever you want to achieve, the way you are able to orchestrate the framework and the strategy which you take up is going to be beneficial, because when we talk about a patent is basically talks about a tenure of 20 years. And perhaps the latest movie I watched, Jurassic Park, whatever the title was, it talked about patenting. And obviously anything related to what I'm very passionate about, somehow I can just see the picture in a very different fashion. So coming to the patent is the provision of the law. So the law itself is very wide. However, we live in a techno legal environment. Most of the folks don't understand that, but it's a very well orchestrated techno legal environment in which we live. And all these handheld devices which we are using, it is a kind of uh, advancement. If utilized with the right intent, it can make life easy in terms of executing so many things at any given point of time. That being said, let's deep dive into Section 14 of the Indian Patent Act. Section 14 is basically a hearing section, and this is triggered. If I have to talk in terms of uh, rolling the dice, it's kind of an event. When we talk about probability, it's always an event which happens, right? So when does this hearing even takes place? When does patent hearing is triggered in terms of, because we were writing some smart contracts and I saw some smart contracts written in a manner where the data set is wrong. And one of the main intent of coming online every day if possible is to talk about data sets which are real, because we cannot do the training on synthetic data set. That's the menace we need to fight in terms of whatever we are doing, because in the name of AI is nothing but an intelligence of a similar event, how the others are able to perhaps overcome that. And when we talk about synthetic data, because there is a correlation before we even come back to Section 14, there is a very big correlation right now that synthetic data is giving rise to hallucinated data set. And that hallucinated data set, when taught to the candidate, because in this portal, the World Wide Web portal, it is giving an opportunity at the same point of time, because of the hallucinating data set, things are not working the way it has to. And a lot can be corrected with the right coding. But for the right coding, it's not that, a particular one organization would be responsible for creating the white economy. It has to be a concerted effort of not only the stakeholders, each and every one of us should be doing this and learning it. Perhaps to understand this techno legal stuff, I'm of the viewpoint that at a school level also, intellectual property rights should become a subject. And it should become a subject since maybe I think nowadays kiddos or the, if I talk about the range, 8-year plus folks, they already are utilizing this device and they should be knowing what intellectual property rights is all about. And they should be learning it till the 12th standard. That's how the education system is in India right now. So this introduction has to come into place. That being said, let's get back to section 14, which is to understand the hearing process. The hearing process is basically at the other end of the admin, there is a human who is called as a patent examiner, having the requisite degrees from a science background to understand what the technology is all about. Many a times, because of the trade secret, when a patent is filed, it is not granted not because the technology is not useful. It is not granted because the person at the other end, who is a patent examiner, is not convinced with whatever has been written. And in many cases, when the person who is the applicant or applicant and inventor, whatever the case may be, is trying to write the framework on his own, because this is not a research paper. Most of the folks falter even if they have something called as invention. If they qualify as invention, they are not able to write it in a manner because this comes with a lot of practice, precision, and there are people in the field who have been trained over the years, and it comes with a lot of focus. It's not that if you invent something you will get a patent out of it, even if you're inventor of maybe first time inventors. So it's always, although the DIY kits are there, do it yourself, I'm not a very big proponent of that, because with this hallucinated data set, the LLM models and everything, anyone and everybody is drafting an application right now and filing it to be an inventor. So two things which are the most boggling right now is being an author, and second is being a patent inventor. Every third or fourth person is an author. Every third person or fourth person is filing a patent application, thinking that they will get a patent and then some company will come and buy them out. That doesn't happen in real life. So section 14 is particularly a triggering event, which is an event which happens when you file for request for examination. There are cases where the best of the companies in the world have taken the strategy of defensive publication. So defensive publication is file a patent application, let it get published, and once it is published, don't file for request for examination. So that is what defensive publication is all about. Per se, it is not very clearly written in the act, but this is what one of the trade secret way of just publishing stuff and making sure that whatever you're developing stays as a trade secret. That being said, let's talk about this particular section 14, because a lot of international players are entering India and they're not aware about it, because even the folks who have cleared the exam recently, somehow they are able to get through these people and doing it at a very low cost, or rather say at peanuts. So they're not able to get things done in a proper manner. But at the same point of time, section 14, so once you file for request for examination, the applicant at the other end, who is a patent examiner, will look into your application, do the database search, analyze everything, and it's kind of a report. So I would rather say this section 14 is like you get a report from the admin, who is a patent examiner, stating that these are the reasons why the application is being refused, which is patent pending. And however, in most of the cases, or in some of the cases, the patent agent is required to make the patent examiner understand, and in legal term we call it as amendment. So amendment generally is done in the patent claims. So patent claims right now, like obviously way back before lockdown or during lockdown or in the initial years or over the years, the way the things were understood in the patenting world was like, patent claims are the heart of the invention. Nothing like that. Now I refute to what I said in those early years, because after the lockdown, this is a new world order. And in the new world order, particularly the stuff which is around the capitalistic way of the running of the different things in terms of the tariffs and the trips agreements the countries are fighting right now. So here you need to understand and be proactive in terms of whether you have to wind up the companies, whether you have to say no to the people you're working with, whether it is to perhaps publish stuff so that you can just protect your whatever you have developed, and at the same point of time you have to make your connection so strong that you can create your own silos of the institutional investors. Because uh, I have seen a lot of good innovators losing the battle or losing the crux of anything and everything because their investors forced upon them that this is how you have to do. Because when investment happens at any given point of time, so it's not that they are being invested in just one companies. Perhaps the kitty is large, maybe the kitty is 100 plus 200 plus companies. So when the kitty is 200 plus companies, just an example, uh, somehow those 200 companies should be working together. So there are retreats, there are perhaps online discussions and everything, how they can work together and stuff. So even if you don't like to work with them for whatever reasons, you still have to it's kind of obeying a kind of an order. And let me tell you, when you are running an enterprise and you're a founder, you cannot obey an order and work around that, because you understand your business well and the other person or the enterprise is never going to understand. So coming back to this stuff, patent claims is not the heart of the invention. Patent claims is kind of a framework stating that whatever is written in the innovation, it is complying with the periphery of whatever has been discussed. I would rather say it's a periphery of a cricket match ground or any of the games which we are playing over the years, or whatever we have been taught over the years. So saying like something which is to create a periphery of the invention in a manner which is legal enough. You have to be your own lexicographer and write anything and everything under, perhaps the wearing clause is very important. When you're reading the patent claims, perhaps not everybody is very conversant with it. It's not what is written in the first few sentences. You have the preamble and the stuff, but what is important is the wearing clause. So wearing clause many times becomes very important, and that is where a good patent agent or patent attorney has to be on your side so they can negotiate that deal with the patent examiner. Okay, so the next stuff under the section 14 would be okay. It is mandatory to a hearing so that the other party is able to explain to the patent examiner as to why whatever has been filed should proceed with the patent grant. And let me tell you, most of the folks don't understand this part. Once that application has been granted, so there are two words which I use interoperably. One is the registration, other is the grant. Third word is not coming to my mind right now, but these are the two words which are generally utilized. Either it's a patent granted or it's patent registered. There's nothing called as international. Tell you, most of the folks are just playing around like we have international patents. International patent is just a language of saying something that I filed before WIPO, and it's there in the database, which is Geneva based, and anyone and everyone can review that. It is per se is not giving you any protection. It is just a way of publishing something, and it opens up window to enter multiple countries if you wish to do so. This strategy was very much, I would rather say, a good strategy way back before 2020. We are in 2025 right now on the timeline. Somehow it doesn't work out. What needs to be worked is to have good frameworks with smart contracts, with the right enterprises, the right stakeholders, and make whatever you're working count on a global scale, be part of these organizations like United Nations, because there are a lot of operators who don't want United Nations to work. It has been working because obviously it's a peacemaking body at the end of the day. So So hearing in India can be done video conferencing. So we have this IoT mode of communicating through the hearing part. It's always good to opt for video conferencing. And there's written submission also. So whatever is being discussed is submitted, and then if FER goes through whatever you have stated, you draft the document, submit it, accepted, good enough, not accepted. SCR is issued. SCR is basically the second examination report. So once the second examination report is there, you can obviously file the reply and then do the hearing or vice versa. But you have to make sure if you are going through the process, which is basically you get a patent grant and you pay annuity fees every year. So that is something you need to look into as far as we are in 2025, depending on the technological landscape. Now the technological landscape is not even 6 months. I mean, every 24 hours, whatever you're thinking, somebody else is already doing that because there's so much open code available right now. It is just how you're orchestrating the framework in a manner which is um, foolproof enough, and that's the power of the blockchain, if any. The patent examiner can refuse the pending patent application under section 15, and if there's appeal, you can go to the IPAB and the high courts and everything. But let me tell you, I will rather take the strategy of getting into the trade secret part, because then it makes my life easy as far as accomplishing the goals, uh, to run the business in a manner and connect with the stakeholders and everything. Because India is a country which is 1 billion plus, and the kind of understanding people have around intellectual property rights is still minuscule. I'll rather say negative in terms of the understanding. And because the understanding is negative, it is not uh, feasible enough to have a US way of working in India, though a lot of people, a lot of entities have been trying this for the last 20 years. I still feel India is in very nascent stage right now. It is just my opinion because I have seen this industry very closely. And till now, most of the applications which are filed, they're getting a design register.